After an application for a guardianship has been approved and scheduled for a hearing, may a court dismiss the petition on the basis that the AIP doesn't need a guardian without a hearing? To find out, you have to read Matter of Elizabeth T.T., but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the episode on the case of People versus Elizabeth T.T., published by the 3rd Department, the Appellate Division 3rd Department, in 2019 on September 19th. The citation for this case is 177 AD 3D 20. And the issue in this case is whether the trial judge of an Article 81 guardianship application can dismiss the petition without a hearing on the basis that the subject, the alleged incapacitated person, is not actually incapacitated, doesn't actually need a guardian, has sufficient advanced directives to accomplish their needs. To understand and appreciate the context of this case, I think the background that's helpful to know, very briefly, is that Article 81 of the Mental Hygiene Law is the section of New York's law that allows and describes the procedure for appointing a guardian for a person who's alleged to be incapacitated, the alleged incapacitated person. We call that person the AIP. I'm going to use AIP from now on in this video. A person is alleged to be incapacitated by virtue of their having functional limitations that impair their ability to perform activities of daily living. And if they're alleged to be incapacitated, the allegation is they need a guardian because the guardian is the least restrictive alternative that will accomplish the goals of preventing them from befalling serious harm as a result of those limitations. The statute says that a court may only appoint a guardian after a hearing. Okay? It says a guardian may only be appointed after a hearing is conducted in the presence of the AIP and pursuant to certain rules and obligations. What are the facts in this case? The facts are that the AIP in this case, the alleged incapacitated person, is 89 years old. She's a mother of 2 daughters. The daughters don't get along. The daughters are Suzanne and Elizabeth. Suzanne's the petitioner in this case. The AIP's husband died in 2007, and she sold her home in Pennsylvania. And thereafter, she basically started living with the daughters, Suzanne and Elizabeth, alternating back and forth for various periods of time. In 2015, the AIP was diagnosed with dementia and Alzheimer's disease. And at that point, she was thereafter, she started living with Elizabeth. The daughters don't get along, like I said. So in June of 2016, Suzanne claimed she was not able to contact or visit the AIP anymore because of the actions of the sister. So in April of 2017, Suzanne filed the Article 81 guardianship application to be appointed guardian based upon allegations that her mom, the AIP, had cognitive impairments, was susceptible to undue influence of her sister, Elizabeth. She also wanted to get visitation schedule and visit with her mom. The court saw the petition, signed the order to show cause, scheduling it for a hearing, appointed a court evaluator, appointed a lawyer for the AIP. And at the first appearance on this case, the AIP consented to an order of visitation, monthly visitation and regular telephone contact. But in December, a few months later, the AIP withdrew that consent, said, I don't want to have that visitation schedule with the petitioner, my daughter, Suzanne, anymore. Suzanne then filed another Article 81 application, now asking additionally for an order requiring the AIP to undergo a court-ordered neuropsychological exam, an evaluation. The court scheduled this for a hearing for May 30th of 2018. Before the hearing, the AIP consented to doing the neuropsych exam, but then withdrew the consent, and instead filed a motion to dismiss. So now the AIP filed a motion to dismiss the case and also to vacate the prior visitation order. And at that point, Suzanne filed a motion to oppose the application to dismiss and filed a motion to compel AIP to undergo a neuropsych exam. The court said, I'm going to hear all these things in an oral argument. I'm going to have an oral argument on May 30th, the day that we were going to do the hearing. Instead of a hearing, we're going to do an oral argument on these 3 applications. The judge then had an oral argument, after which he dismissed the petition, saying, I find that the AIP adequately understands and appreciates the nature of her circumstances and has adequate resources to address her needs. Petition dismissed. At that point, petitioner then appealed, said you can't do that, and it goes to the appellate division, and that's this case. Suzanne said you can't deny my application to dismiss this case without a hearing. And the appellate division says Suzanne is correct. The holding here is that when an AIP does not consent to the appointment of a guardian, the court must undertake a two-part analysis. Is the appointment necessary? And is the AIP incapacitated? The court may not just say, I think the AIP has sufficient resources or is aware or is not incapacitated without doing a full-blown hearing. The court also must consider the report of the court evaluator that was appointed to assess the sufficiency and reliability of the advanced directives or available resources. And it has to be based upon clear and convincing evidence. Here, they say, because the petition was sufficient, it said dementia, it said Alzheimer's, it said undue influence, that was sufficient for a hearing, and the court may not at that point make any conclusions about capacity or incapacity without conducting a full-blown hearing. So the petition was restored. It gets sent back down to the judge in Chemung County to actually conduct an Article 81 hearing. So the answer here is the holding here is you must conduct a hearing once the petition is signed. You can't dismiss it in the absence of a hearing to make a determination that the AIP actually has capacity or lacks capacity. That's the case of matter of Elizabeth T.T. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.